After 34 years of being a general commercial litigator, I decided general commercial litigation was going away, and I needed, actually, despite resisting that for 34 years, to specialize. So now about half my practice is M&A disputes, and among the rest of it, I include trade secret disputes. And so that's what I'm going to talk about today. And there are two main things that I want, I realize there's two main themes here. One is how we can act like corporate lawyers in resolving trade secret disputes. And the other is to talk a little bit about the forensics and the technology and how that helps us to prove and to establish these kind of disputes. And I'm a little nervous talking about this because I am very new to this practice area, and I'm sure 100% there are people in the room who know a lot more about this than I do. So these are just sort of my observations from the things I've been doing in the last handful of years. And I know we have time for people to contribute at the end, so please jump in and talk about your experiences. So under the heading of how we can act like corporate lawyers, I think this is a practice area we actually can really contribute because we see the problem after it's a problem and see the problem in the agreements that we're trying to litigate and can go back to people, go back to the client, go back to the corporate lawyer and say, here's a suggestion on how to fix your agreement. And I realized I came up with one of these this week. We're litigating some customer list disputes for a national insurance brokerage. And a lot of the defenses in these cases are, I brought this customer to the dispute, to this company to begin with. So when I take that customer with me, when I leave, I am not taking any trade secrets. I am simply taking my own customer. And it occurred to me, and I don't quite know whether this works yet, so people can tell me if it does, but that if we put into the agreements a provision saying anybody you brought here is not your customer anymore because you are adding to it trade secrets and confidential information developed while you are at this business, then you can't take that because now it is a trade secret. So put something in the agreement that's going to help you litigate it. One good suggestion for that is to ask the client if you can take a look at their confidentiality agreements every year and see if there are things in them that need to be updated. And one example from California is that there's a recent case within the last couple of years that I don't think it 100% really holds this, but people are interpreting it to bar anti-employee solicitation clauses. So if you have a provision in your agreements, and a lot of companies do, saying when you leave, you agree you will not solicit any other employees to come with you, you might want to take a look at that, because I was in a case where the other side was arguing that that provision then invalidated the entirety of the agreement. I don't think that's true, but you avoid that argument if you take things out that courts have held to be unenforceable. Another thing you could do in anticipation is make sure that you're avoiding problems during merger and acquisition transactions. Take a look at the agreements of the company that is being acquired. Make sure that they even maybe have people re-sign the agreements. I know that happens before the acquisition closes. Other things you can do to kind of prevent problems from happening at all, limit access. A lot of companies just let anybody see anything. Make sure that they put in place procedures so that people see things on a need-to-know basis. This one, I think, incoming employees, training people how not to ask the new employee for information about their prior job and things they worked on before they came. We were asked to help out a client in advising on exactly that situation. Employee came in and posted information he had taken from his prior job. Nice. And now they're trying to contain the problem. So, you know, when someone's coming in and has worked for a competitor, instructions on what not to do. Same thing, don't instruct your employees not to solicit that kind of information from new hires. Sometimes, and this is actually probably only in the case of high-level employees, but you may want to have separate counsel to talk to a new employee who's got all kinds of hot-button information about what can and cannot be said and what can and cannot be shared, because these are really tricky areas. And this is probably as good a time as any for me to say that I think, at least in California, where I practice mostly, that I think the trade secret litigation has kind of become the new patent litigation, where 10 years ago, before the laws changed, or 20 years ago, that was the hot area, was patent litigation. And now what we see is everybody suing everybody. This new employee brought trade secret information with him. This new employee brought all kinds of other information. You illegally access this information. In the course of an acquisition, there's a lot of litigation over that. There's NDAs. People talk about, oh, let's do something together, joint venture, or let's do something together. I'd like to acquire you. The deal doesn't happen. And then 6 months, a year down the road, somebody's suing, saying you stole my trade secret information. So I think this is a really growing area in that respect. So the other thing that I really wanted to talk about, so that's how to act more like a corporate lawyer, preventing problems, thinking about how the agreements are written so that when you have to litigate them, and this is something I do all the time in the M&A disputes practice too, is think about something, you look at the provision, you think, this is really terrible, I don't like this. Or you get a case and you look at the agreement and say, this is fantastic. Who else would want to have this agreement? And just kind of anticipating that way, whether they're corporate lawyers in your firms or just, I think it's a good, following on what Ross said, that's a value add for a litigator, for a client who is not maybe thinking about those kinds of things where you're just in a litigation shop. So that was the first thing I wanted to talk about. The second thing is where is the forensic piece of this, and this is just fun to me. Is you find what people do. It is unbelievable how stupid people are, and it's just amazing what you can find when you start looking into these things. And we had something which was actually a trade secret case that came out of a failed acquisition, and we pulled all of the documents that we had from these employees who had left, and then, I mean, they were complete snakes. They were busy negotiating their new deal before they were out the door, and they tried to keep it on their Gmail accounts, but they failed because auto population on email is amazing, and it'll sometimes pop up not the Gmail address, but the work address. So we found all kinds of evidence that they were sending financial statements and lists of employees and all kinds of things to what they thought was going to be their new employer before the deal fell apart. And once we found that stuff, and it was quick and it was easy, and the client was like, didn't really cost that much to get to this stuff. We settled that case so fast and so favorably for our client. And I'm doing things now that same kind of thing. You find a lot of people sending stuff to themselves, and before they know they're on their way out the door, they're sending stuff to their Gmail account. The forensic consultants can find where someone has stuck a flash drive into the computer and downloaded all kinds of stuff. That leaves traces. If they connect through their network somewhere else other than their office, that's traceable. If they try to delete stuff off their computers because they want to make sure that no one can see what they did, that's traceable. We have a case right now where the employee put some kind of software on the computer to wipe it clean so that you couldn't see what she had deleted. Well, but she's the only one in the office who has that software on her computer. So then gives you the argument, well, what were you doing with that software wiping your computer clean? There are lots and lots of companies that do this kind of consulting now, and it's really valuable. It's money well spent. Some are better than others at doing that, but I'm just astounded at how stupid people are. And what they think they can get away with. And sometimes even tech people. I mean, this guy, he's now been indicted, right? The guy who worked at Google on the autonomous cars and then took all his information to Uber. I mean, that guy knows tech, right? He should know that it was traceable, exactly what everything he walked out the door with. So that's the first. Don't assume people are smart just because they may have advanced degrees in engineering. The other thing that I do want to talk about, because this is something I've recently become very interested in, and it is a place where you can find information. And I know less than nothing about what I'm about to say, so I had actually brought someone into our firm to talk about this. But there are all kinds of communication devices, not devices, but methods that people are using now that we don't think about. I mean, we think about email. But I mean, I recently realized that even people who don't live in the Bay Area don't know what Slack is. Now, Slack is kind of a text or an instant messaging type communication device that is very, very widely used in a lot of companies. People create channels for certain kinds of communications and projects that they're working on so they don't get lost in the massive emails. And there are a lot of tech companies in the Bay Area that do not use email anymore. They do all their communications over Slack. And there are other devices, there are other communication methods and products like Slack that a lot of our clients are using that we may forget to ask about, and where we may be able to find things for these kinds of trade secret cases. And one example of that, why we need to look in these places, is in the Boeing MAX cases. There was recently a revelation about engineers talking to each other, ridiculing the regulation that had been done of the MAX, and, oh, you know, we wouldn't put our families on that plane. Those communications did not take place over email. They took place over one of these other alternative communications methods. So
they weren't produced.
And they weren't produced.
Unbelievable.
Because people didn't know, I think a lot of times didn't know to ask for them. You know, people now, I think we know to ask for phones, but you know, what kinds of pictures people take. I heard of some where people had taken pictures of whiteboards where all kinds of trade secret information was laid out, and then they walk out of the company with that picture on their phone. They may not even think about it, and it's got all of that trade secret information on it. There are other kinds of internal intranet networks that companies use that have chat features or comment features on them. People create private Facebook groups, employees do. Then people leave the company, but they stay in these Facebook groups. There's all kinds of information that gets disseminated that way. Just to think, I guess my only point on this is just to think about what other kinds of communications methods people may be using, because I know top of mind is always emails, but there may be now myriad other communication methods to look at. So that's all I had to say. And I'm sure, like I said, that people in the room have much more experience than I do on some of these things and something to add.
Well, Meryl, thank you.